Gun safety groups say that the changes may make it harder for law enforcement agencies to fight crime.
We are here supporting the Constitution. We're supporting the great American people. We're going to be signing just about as many rules as have been proposed during my entire 20 years with this agency.
People across our Commonwealth and the rest of the country have been impacted by acts of gun violence.
There's no magic fix, no single law that will end gun violence once and for all.
The reality is that the laws that are on the books, you don't get to choose which ones people are going to follow.
Nothing in this bill will make the people in these communities safer as they sit on their porch or kids go to school.
If you own an AR-15, a suppressor, or a short-barreled rifle, the legal ground beneath your feet is shifting faster than at any other point in American history. We have officially entered an era of legal whiplash, where the federal government is tearing down decades of gun control regulations while individual states are building massive legal barricades to trap you the second you cross their borders. This geographic legal divide has created a dangerous minefield for the average citizen, turning perfectly law-abiding gun owners into instant felons overnight simply for driving across an invisible state line. The contrast between federal deregulation and aggressive state-level retaliation has reached a boiling point, and the consequences of this legislative civil war are playing out in local police stations and federal courtrooms across the nation. To truly understand how deep this division runs, we have to look at a shocking decision handed down in the federal courts on July 9, 2026. The Seventh Circuit Court of Appeals issued a highly controversial 2-1 ruling upholding the Protect Illinois Communities Act, which is the state's sweeping ban on assault weapons and high-capacity magazines. Writing for the majority, U.S. Circuit Judge Amy St. Eve argued that the state's ban was consistent with the historical traditions of the United States because the nation has a long history of regulating particularly dangerous weapons. To justify this claim under the Supreme Court's rigorous historical standards, the court compared modern semi-automatic rifles like the AR-15 to 19th century Bowie knives. The court noted that when the Bowie knife became a popular and exceptionally lethal weapon in the 1830s, causing gruesome injuries and rising violence, pre-Civil War legislatures responded by heavily restricting or outright banning their carry and sale. This Bowie knife analogy has sent shockwaves through the legal and Second Amendment communities, drawing fierce criticism from gun rights advocates and a scathing dissent from U.S. Circuit Judge Michael Brennan. In his dissent, Judge Brennan argued that the majority completely misapplied the historical tradition standard established by the Supreme Court in its landmark 2022 decision, New York State Rifle and Pistol Association v. Brune. Under the Brune framework, the government cannot simply point to any old weapon regulation from the 19th century to justify a modern ban. They must prove that the banned firearm is not in common use for lawful purposes today. Because the AR-15 is the single most popular rifle in America, with millions of law-abiding citizens owning them for self-defense, sport, and hunting, critics argue that comparing a standard semi-automatic rifle to an early American fighting knife is a massive stretch of legal logic that ignores the core tenets of constitutional law. The battle over the Bowie knife analogy perfectly illustrates the state of constitutional chaos in 2026. Ever since the Bruen decision forced courts to evaluate gun laws based solely on text, history, and tradition, gun control lawyers have been forced to dig up obscure historical laws to defend modern restrictions. This has led to a bizarre legal landscape where the future of your constitutional rights depends on how a judge interprets a century-old law about pocket knives, traps, or colonial gun storage. While the judicial branch is deeply divided over these historical comparisons, the executive branch at the federal level has been moving in an entirely different direction, embarking on one of the most rapid and unprecedented periods of firearms deregulation in modern history. This federal deregulation trend began in earnest on January 1, 2026, when a massive legislative shift went into effect that completely eliminated the National Firearms Act's $200 federal tax stamp for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. When the National Firearms Act was originally passed in 1934, the $200 tax was intentionally designed to be a prohibitive financial barrier, equivalent to several $1,000s in today's money, effectively keeping these items out of the hands of everyday citizens. By dropping this tax stamp fee to exactly $0, the federal government removed a massive financial hurdle, triggering a massive wave of new NFA applications from gun owners who had previously been priced out of the market. The impact of dropping the NFA tax stamp to $0 was immediate and overwhelming. On New Year's Day of 2026 alone, the Bureau of Alcohol, Tobacco, Firearms, and Explosives was flooded with over 150,000 electronic applications as gun owners rushed to register suppressors and short-barreled rifles. This surge in demand has permanently altered the American firearms market, transforming suppressors from niche, stigmatized accessories used by Hollywood villains into standard safety equipment used by millions of hunters and sport shooters to protect their hearing. Short-barreled rifles, once considered highly specialized and dangerous weapons, have similarly transitioned into the mainstream as the go-to choice for home defense due to their maneuverability in tight indoor spaces. However, a crucial detail that many online commentators and casual observers get wrong is that dropping the tax stamp to $0 did not actually repeal the National Firearms Act or deregulate these items entirely. The rigorous registration process is still fully in place, meaning that any citizen wishing to acquire a $0 NFA item must still submit their fingerprints, passport-style photographs, and undergo an intensive federal background check through the electronic filing system. The items must still be registered in a national database, and transferring them to another individual without federal approval remains a high-level felony. The only thing that changed was the elimination of the financial penalty, a move that gun rights advocates praised as a major win for working-class citizens, but one that quickly drew the ire of gun control advocates. The federal push toward deregulation gained even more momentum in the spring of 2026. Following the Senate confirmation of a longtime law enforcement veteran, Robert Shikata, as the new director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Sworn in on April 30th, 2026, Director Shikata immediately signaled a dramatic shift in the agency's enforcement priorities. Shortly after taking office, the ATF proposed and began implementing a sweeping package of 34 distinct regulatory changes designed to roll back several of the most controversial rules enacted during the previous administration. This package, which the agency publicly marketed as a common-sense regulatory alignment, marked a historic departure from the aggressive enforcement tactics of the early 2020s. Among the most significant rollbacks in Director Shikata's package was the formal dismantling of the controversial 2023 pistol brace rule, which had previously attempted to reclassify millions of brace-equipped pistols as short-barreled rifles under the NFA. The ATF also scaled back the expansive engaged in the business definition, which had threatened to require casual gun collectors and hobbyists who sold even a single firearm online or at a local gun show to obtain a federal firearms license. By narrowing these definitions back to their traditional statutory boundaries, the ATF provided massive relief to millions of gun owners who had been living in constant fear of administrative prosecution. In addition to redefining what constitutes a firearm, Director Shikata's reforms targeted the ATF's controversial zero-tolerance policy for federal firearms licensees. Under the previous guidelines, the agency had shut down hundreds of family-owned gun shops over minor non-willful clerical errors, such as simple typos in a customer's address or a missing checkmark on a form. The new 2026 Administrative Action Policy shifted the agency's focus back to public safety outcomes rather than administrative technicalities, prioritizing education and corrective action for honest retailers while focusing strict criminal enforcement on actual intentional firearms traffickers who supply weapons to violent criminals. Another major administrative change in the 2026 ATF package was the elimination of the frustrating ATF Form 20 requirement for temporary interstate travel. Previously, any owner of a registered short-barreled rifle or short-barreled shotgun was federally required to submit a Form 20 and wait weeks, sometimes months, for written approval from the ATF before they could legally transport their firearm across state lines, even for a weekend shooting competition or a hunting trip. Under the new rules, this requirement was dropped for any temporary travel lasting less than 365 days, allowing legal owners to travel freely across the country with their registered property without needing prior federal permission. To make NFA ownership even more practical for families, the ATF also introduced a proposal for joint spousal registration of NFA items. Historically, if a husband legally purchased a suppressor under his own name and left it in the family home where his wife had access to it, the wife could technically be prosecuted for illegal possession of an unregistered NFA item. To avoid this legal trap, gun owners were forced to pay hundreds of dollars to attorneys to establish complex legal gun trusts. The new joint registration rule allows married couples to register NFA items under both names simultaneously, at no extra cost, removing a major bureaucratic barrier and protecting families from accidental prosecution. Predictably, this rapid wave of federal deregulation has sparked a massive backlash from progressive state governors and gun control coalitions who view the ATF's new direction as a complete betrayal of public safety. Arguing that the federal government has abandoned its duty to protect citizens from gun violence, several states have taken matters into their own hands, rushing to pass highly restrictive local laws designed to completely nullify the federal rollbacks. This has created an unprecedented legal standoff, where what is fully legal, registered, and encouraged at the federal level is treated as a severe criminal offense the moment you cross certain state borders. The most intense battleground in this state-level counteroffensive has been Virginia, where Governor Abigail Spanberger signed House Bill 2107 into law on May 14, 2026. This aggressive piece of legislation placed a strict ban on the future sale, transfer, manufacture, and import of what the state defines as assault firearms, while also limiting ammunition magazine capacities to a maximum of 15 rounds. The Virginia law was specifically written to counteract the rising popularity of modern sporting rifles, but its implementation has been marked by absolute legal chaos as gun rights organizations immediately filed lawsuits to block the ban. The legal battle over Virginia's House Bill 2117 has created a dizzying patchwork of local enforcement. In late June of 2026, local county courts issued a series of conflicting temporary injunctions, blocking the enforcement of the ban in specific counties while allowing it to remain active in others. This has left Virginia residents in a state of complete confusion, where possessing a certain semi-automatic rifle or a standard 17-round magazine is entirely legal in one county, but could lead to a felony arrest if you drive 15 minutes down the road into a neighboring jurisdiction. The lack of statewide uniformity has made everyday life incredibly stressful for local gun owners who are simply trying to stay on the right side of the law. Virginia is far from alone in its aggressive pushback against the federal trend. In Massachusetts, state officials have rolled out a mandatory centralized electronic gun registration portal with a strict compliance deadline set for October of 2026. This system requires every gun owner in the state to register their firearms, including previously grandfathered items, into a state database, creating a level of tracking that goes far beyond federal requirements. Meanwhile, Colorado has implemented strict new age limits that prohibit anyone under the age of 21 from purchasing any form of ammunition, and California has enacted highly punitive security standards for local gun dealers that have forced dozens of small businesses to close their doors. This extreme polarization has set a terrifying trap for the average American gun owner who travels for work, vacation, or family visits. Imagine a scenario where a citizen living in a gun-friendly state like Texas or Tennessee legally purchases a short-barreled rifle under the new federal $0 tax stamp laws, completes the rigorous background checks, and receives their official registration from the ATF. Because the ATF eliminated the Form 20 travel requirement, this citizen believes they are fully compliant with federal law and decides to drive to Virginia or Massachusetts for a family gathering, carrying their registered firearm locked securely in their vehicle. The second this traveler crosses the state line, they enter a completely different legal reality, even though their firearm is registered with the federal government and is fully legal under the laws of their home state. Local state laws in Virginia or Massachusetts do not care about federal registration or the $0 tax stamp. In those jurisdictions, simply possessing that specific rifle or a standard capacity magazine is a high-level felony that carries mandatory prison time. The traveler, who has never committed a crime in their life and has fully complied with every federal law, suddenly faces the prospect of arrest, a destroyed career, and a lengthy prison sentence just because they crossed an invisible border. Many gun owners mistakenly believe that they are protected in this scenario by the Federal Firearm Owners Protection Act of 1986, commonly referred to as FOPA. This federal law was specifically designed to protect citizens who are legally transporting firearms through states with highly restrictive gun laws, provided the weapon is unloaded, locked in a container, and not readily accessible from the passenger compartment. However, in practice, hostile states like New York, New Jersey, and Massachusetts have found ways to bypass these federal protections. Local law enforcement officers in these areas routinely arrest travelers first, seize their firearms, and leave it up to the citizen to spend tens of thousands of dollars on criminal defense attorneys to prove their FOPA compliance as an affirmative defense in a state-level trial. This high-stakes legal warfare is ultimately headed for a final showdown at the United States Supreme Court. The highest court in the land has recently agreed to review major assault weapon ban cases, including challenges to Cook County's ban and a similar law in Connecticut. The court's upcoming decisions will have to directly address the conflict between the Seventh Circuit's controversial Bowie knife standard and the original intent of the Bruin decision. If the Supreme Court rules that state-level bans on common firearms are unconstitutional, it will restore a level of national uniformity and end the state-line traps that currently threaten gun owners. If they decline to strike down these bans, the United States will remain permanently divided into two distinct legal territories, with completely different rules of citizenship. The lesson of 2026 is that being a responsible gun owner now requires you to be a self-taught constitutional scholar and a highly vigilant researcher. You can no longer rely on the fact that your firearm is registered, legal at the federal level, or compliant with the laws of your home state. As long as individual states continue to wage their war of attrition against federal deregulation, every trip across a state line carries immense risk. To protect yourself and your family, you must stay deeply informed about local legislative changes. Participate in public comment periods and always research the specific laws of every single state you plan to travel through. Because in this current legal climate, ignorance of a local county ordinance is a mistake that could cost you your freedom.